Good morning, Honorable President, Honorable Judges, dear audience. Honorable President, this is a sitting of the court to deliver decisions with respect to matters before the court. At this sitting, the court will be delivering 9 decisions, 5 against Tanzania, 2 against Mali, 1 against Benin, and 1 against Cote d'Ivoire. The current bench will be delivering the decisions with respect to the United Republic of Tanzania. Honorable President, just to indicate also that Council for the matter of 042 of 2020, TK Mwambipile and Equality Now are present in court. Thank you, Honorable President.
Merci, Dr. Eno.
Dr. Eno,
Je vais donner la parole
allow me to give the floor
Chubesa
to Judge Chibesa
de donner lecture
so that
de la décision
we hear
Christian Tuguri
the reading of the matter of Tuguri and Tanzania.
Cette décision sera tenue par
Or rather,
le...
it's going to be read by Judge Kyoko.
Cher Kyoko, vous avez la parole.
Yeah, this is the judgment of the court in the matter of Martin Christian Musunguri versus United Republic of Tanzania. Application number 052 of 2016, judgment. The court composed of Blaise Chikaya, Vice President, Ben Kyoko, Rafa Benashu, Susan Menge, Tujilane R. Chisumira, Shafika Ben Saula, Stella I. Anukam, Dumisa B. Zabeza, Modipo Sako, Dennis D. IJ, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, and Rule 9.2 of the Rules of Court, hereinafter referred to as the rules, Justice Imani D. Aboud, President of the Court and a national of Tanzania, did not hear the application. Facts of the matter. It emerges from the record that the applicant was charged for the murder of 3 children The murders occurred on 18th December 2003 at Businde Village, Karagwe District, at a time when the applicant was a soldier and a militia trainer of the Tanzanian People's Defense Force. On 30th July 2010, the High Court of Tanzania, sitting at Bukoba, convicted and sentenced him to death by hanging. Dissatisfied with this decision, he appealed to the Court of Appeal of Tanzania, sitting at Mwanza, which dismissed the appeal in its entirety on 11th March 2013. On 12th March 2013, the applicant filed before the Court of Appeal an application for review on the ground of manifest errors in the first judgment. At the time of filing the present application, the request for review had neither been heard nor listed for hearing. According to information filed by the respondent state, on 14th December 2018, the Court of Appeal eventually dismissed the application for review for lack of merit. In view of the number of judgments that we are delivering this morning, we're going to be skipping certain sections of judgments so that we don't take too long. I'll now go to the prayers of the parties. The applicant prays the court to direct the respondent state to vacate the death sentence and grant the applicant a new trial that comports with the fair trial guarantees of the African Charter, and in the alternative, set aside the death sentence and grant the applicant a resentencing hearing, and third, amend this law to ensure the respect for life. In response, the respondent states praise the court to declare that it lacks jurisdiction to hear the application, declare that the application is not admissible for not exhausting local remedies and not being filed within a reasonable time. Third, find that the respondent state has not violated any of the provisions as alleged by the applicant. And four, dismiss the prayers of the applicant and order the latter to bear the cost of the proceedings. And now I'll go straight to the orders of the court. Of course, the court has considered all issues relating to jurisdiction, admissibility, the objections filed by the respondent state, and also the issue of reparations. And the orders of the court are as follows. For these reasons, the court unanimously on jurisdiction dismisses the objection to its jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objections to the admissibility of the application and declares the application admissible. On merits, finds that the respondent state has violated the right to life protected under Article 4 of the Charter in relation to the provision in the Penal Code for the mandatory imposition of the death penalty, as it removes the discretion of the judicial officer. Further, finds that the respondent state has violated the applicant's right to be tried without undue delay, protected under Article 7(1)(d) of the Charter. 7, finds that the respondent state has violated the applicant's right not to be subjected to inhuman and degrading treatment protected under Article 5 of the Charter in relation to the lengthy pretrial detention on death row, and confinement. On reparations, pecuniary reparations, grants Tanzanian shilling 7 million to the applicant for moral damage that ensued from the violations found. 9, orders the respondent state to pay the amount indicated under subparagraphs 8, free from taxes within 6 months, effective from the notification of the judgment, failing which it to pay interest on arrears calculated on the basis of the applicable rate of the Bank of Tanzania throughout the period of delayed payment and until the accrued amount is fully paid. Non-pecuniary reparations. Orders the respondent state to take all necessary measures within 6 months from the notification of this judgment to remove the mandatory imposition of the death penalty from its laws. 11, orders the respondent state to take all necessary measures within 1 year of the notification of this judgment for the rehearing of the case on the sentencing of the applicant through a procedure that does not allow the mandatory imposition of the death sentence. 12, orders the respondent state to publish this judgment within a period of 3 months from the date of notification on the websites of the Judiciary and the Ministry of Constitutional and Legal Affairs, and ensure that the text of the judgment is accessible for at least 1 year after the date of publication. 13, orders the respondent state to submit to it within 6 months from the date of notification of this judgment a report on the status of implementation of the decision set forth herein, and thereafter every 6 months until the court considers that there's been full implementation thereof. On costs, orders that each party shall bear its own costs. This judgment is signed by all the judges that I mentioned at the beginning and the registrar. In accordance with Article 28, Sub-Article 7 of the protocol and Rule 70, Sub-Rule 1 of the rules, the separate opinion of Judge Blaise Chikaya is appended to this judgment. Done at Arusha this first day of December in the year 2022 in English and French, the English text being authoritative. That is the judgment of the court.
L'affaire suivante, c'est
This matter
Egola
is the matter of Egola Iguna,
par la juge Anouka.
which is going to be presented to the court by Judge Anokam. Dear colleagues, you have the floor. Thank you, Honorable President.
I shall be reading the judgment in the matter of Egola Iguna versus the United Republic of Tanzania. Application number 020/2017. And the judgment is delivered today, the 1st of December, 2022. The court, composed of Blaise Chikaya, the Vice President, Ben Kyoko, Rafa Benashu, Susan Menge, Tujilend R. Chizomila, Shafika Bensaola, Stella I. Anukam, Domisa B. Insebisa, Modibo Sako, Dennis D. Ajay, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9 sub 2 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani D. Aboud, the President of the Court and a national of Tanzania, did not hear this application. And in the application, we have the applicants, Mr. Egola Iguna, self-represented, and the United Republic of Tanzania, represented by Dr. Boniface Luhandi, Solicitor General of the Solicitor General's Office. He is accompanied with 5 other officers from the same office. After deliberation, the court renders the following judgment. I begin with the facts of the matter. It emerges from the record that on the 22nd of April, 1993, the applicant and another person, not before the court, broke into the house of Humba Lumiki, then attacked and wounded her with a machete. Ms. Lumiki's son, having been awoken by his mother's screams, ran to her aid. In the course of the attack, he was also injured by the applicant, after which the applicant escaped. Ms. Lumiki was later rushed to the hospital where she died from her wounds. The applicant and his accomplice were arrested 4 months after the attack on Ms. Lumiki and charged with murder. On the 27th of March, 2001, they were convicted before the High Court of Tanzania, sitting at Tabora, and sentenced to death by hanging. The applicant filed an appeal against the decision of the High Court, and the appeal was dismissed by the Court of Appeal on the 28th of June, 2003. The prayers of the party before this court. The applicant prays the court to make an order quashing both the conviction and the sentence. Secondly, to order his release from custody. Thirdly, to grant him reparation to the tune of Tanzania shillings 59,136,000, pursuant to Articles 27 sub 1 of the protocol establishing this court. Lastly, grant any other legal remedy that the court may deem fit in the circumstances of the applicant's complaint. The respondent states in return prays the court for the following. 1, that the applicant's application for reparation be dismissed in its entirety. Secondly, that a declaration be made that the respondent state has not violated the provisions of the charter and that the applicant was treated fairly by the respondent state. Lastly, any order this court may deem right and just to grant under the prevailing circumstances. Having considered the issue of jurisdiction, admissibility, and the merits of this court, I will just read the operative parts of our judgment. For these reasons, the court on jurisdiction unanimously declares that it has jurisdiction. On admissibility, by a majority of 7 judges for and 3 judges against, Justice Ben Kyoko, Tijalen R. Shizomila, and Dennis D. Ajay dissenting, declares the application admissible. On the merits, unanimously finds that the respondent state did not violate the right to a fair trial protected under Article 7 of the Charter in relation to its evaluation of evidence. The court also on merit finds that the respondent state did not violate the right to non-discrimination protected under Article 2 of the Charter in relation to its decision. On reparations, dismisses the prayer for reparation. On cost, orders each party to bear its own cost. This judgment is signed by the bench, as I earlier mentioned, and in accordance with Article 28(7) of the protocol and Rule 71 of the rules, the separate opinion of Justice Blaise Shikaya and the joint dissenting opinion of Justice Ben Kyoko, Justice Tijalen R. Chizomila, and Justice Dennis Diaje are appended to this judgment. Done at Arusha, this first day of December in the year 2022, in English and French, the English text being authoritative. This is the judgment of the court. Thank you.
Cher collègue Adji, vous avez la parole.
Application number 34/2017.
And sentenced to 5 years and 30 years imprisonment for the offense of burglary and armed robbery, respectively. He was also ordered to pay compensation to the victim for the items which were stolen, but not recovered for the injury sustained by the victim. The applicant appealed to the High Courts of Tanzania in Tabora in criminal appeal number 134 of 2004 against the conviction and sentence of the District Court of Nziga, which appeal was dismissed by the High Courts on 17 July 2006. The applicant then appealed to the Court of Appeal of Tanzania at Tabora in criminal appeal number 332 of 2007 against the conviction and sentence of the High Court of Tanzania, Tabora. The appeal was dismissed by the Court of Appeal in a judgment delivered on 1st of June 2010. Prayers of the parties. The applicant praised the court to A, restore justice where it was overlooked. B, quash both the conviction and sentence of 30 years in jail meted against him. C, release him from prison custody. D, order the respondent state to compensate him to the tune of Tanzanian shillings 65,800,000, which he would have earned out of his agricultural produce. And E, order the respondent state to compensate him for special damages to an amount that the court deems fair in the circumstances. In its response on jurisdiction and admissibility, the respondent state praised the court to A, declare that it is not vested with jurisdiction to adjudicate over this application. B, declare that the application has not met the admissibility requirements under Rule 45 and 6 of the Rules of Court. C, declare that the application is inadmissible. D, dismiss the application. On the merits, the respondent state praised the court to A, declare that the government of the United Republic of Tanzania did not violate the applicant's rights provided by Article 2 of the African Charter on Human and People's Rights. B, declare that Tanzania did not violate the applicant's right provided by Article 3, 1, and 2 of the African Charter on Human and People's Rights. C, declare that Tanzania did not violate the applicant's rights provided by Article 7.1 of the African Charter on Human and People's Rights. D, declare that Tanzania did not violate the applicant's right provided by Article 7.1c of the African Charter on Human and People's Rights. E, declare that Tanzania did not violate the applicant's right provided by Article 7.1d of the African Charter on Human and People's Rights. F, declare that Tanzania did not violate applicant's right provided by Article 107(2)(b) of the Constitution of the United Republic of Tanzania, 1977. G, dismiss the application in its entirety for lack of merit. H, dismiss the applicant's prayer in entirety. I, dismiss the applicant's prayer for reparation. And J, order the respondent to pay the cost of this application. I skip the discussions on jurisdiction and admissibility and move to the operative parts. Operative part. For this reason, the court unanimously on jurisdiction, I, dismisses the objection to temporal jurisdiction. I, dismisses the objection to material jurisdiction. I, declares that it has jurisdiction. On admissibility, by a majority of 7 and 3 against, Justices Rafa Benashaw, Tafika Bensaula, and Dumisa B. Insebisa dissenting. 4, finds that the application was not filed within a reasonable time. H, declares the application inadmissible on cost. Unanimously orders each party to bear its own cost. Signed, Brice Chikaya, Vice President, Ben Kioko, Judge, Rafa Benashaw, Judge, Susan Mingi, Judge, Fisimira, Judge, Bensawula, Judge, Enukam, Judge, Insibisa, Judge, Sako, Judge, Eji, Judge, Robert Eno, Registrar. In accordance with Article 28(7) of the Protocol and Rule 71 of the Rules, the dissenting opinions of Judge Raphael Benashaw, Judge Tafika Bensaula, and Judge Dumisa Insibisa are appended to this ruling. Done at Arusha, the first day of December in the year 2022 in English and French, and English test being authoritative. Thank you, Mr. President.
Quelle est la décision de la Cour? L'affaire
Ruling of
suivante,
the court. The next matter
l'affaire Ngati Mwita.
is Ngati Mwita, and this judgment will be read by Honorable Judge Anukam. Judge Anukam, you have the floor. Thank you, Mr. President.
Ngati Mwita versus the United Republic of Tanzania. Application number 012/2019. Judgment on this day, the 1st December 2022. The court composed of Blaise Shikaya, Vice President, Ben Kioko, Rafa Benashu, Susan Menge, Tujalen R., Shizomila Shafika Bensaola, Stella I. Anukam, Misat B. Nsabisa, Modibo Sako, Dennis D. Ajay, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9(2) of the Rules of Court, hereinafter referred to as the Rules, Justice Imani Diabu, the President of the Court, and the National of Tanzania did not hear the application. The subject of the application, I read towards the facts of the matter. It emerges from the record that on the 4th of February 2008, the applicant allegedly set on fire Mr. Madadi Alius, a fisherman who was in her employ, by dousing him with kerosene in retaliation for his alleged theft of the applicant's fishing boat. Mr. Alius subsequently died as a result of the injuries sustained from his burns. On the same day, the 4th of February 2008, the applicant was arrested and charged before the High Court sitting at Wanza with the offense of murder. The preliminary hearing was conducted on the 15th of February 2010, and the trial commenced on the 29th of November 2010. In his judgment dated the 19th of September 2011, the High Court found the applicant guilty of murder and sentenced her to death by hanging. On the 11th of March 2013, the Court of Appeal sitting at Wanza dismissed the applicant's appeal against her conviction and sentence. She then filed an application for the review of the Court of Appeal's decision, but this was dismissed on the 19th of March 2011. I now read the prayers of the parties before this court. In her amended application, the applicant prays the court for the following. 1, a declaration that the respondent state has violated her rights under Articles 1, 7, the right to fair trial, 4, the right to life, 5, the right to dignity of the Charter. Also, an order that the respondent state release the applicant from prison with immediate effect. Thirdly, an order quashing the death sentence imposed by the respondent state on the applicant. Fourthly, an order requiring the respondent state to pay reparations to the applicant as follows. A, payment of $34,308 United States dollars as reparation for damage suffered by the applicant. B, payment of reparation in an amount the court considers reasonable on account of material prejudice suffered. C, payment of reparation in the amount of United States dollars 13,000 on account of legal and related expenses. Fifthly, an order compelling the respondent state to amend its penal code and related legislation pertaining to the death sentence in order to make it compliant with Article 4 of the Charter. Lastly, such other measures as the court deems fit. The respondent state in return, as regards jurisdiction and admissibility, prays the court to rule as follows. 1, find that the Honorable Court lacks jurisdiction to hear the application. 2, find that the application has not met the admissibility requirements provided for in Article 56 sub 6 of the Charter, read together with Rule 50 sub 2 sub F of the Rules of the Court 2020. Lastly, declare the application inadmissible. On the merits of the application, the respondent state prays the court to 1, find that it did not violate the applicant's right to life, right to dignity, and right to fair trial as provided for in Articles 4, 5, and 7 of the African Charter on Human and People's Rights. Secondly, find that it did not violate Article 1 of the African Charter on Human and People's Rights. Thirdly, find that the applicant was tried and convicted in accordance with the relevant laws and the international human rights standards. Lastly, dismiss the application in its entirety with cost. In relation to reparation, the respondent state praised the court to one, find that the interpretation and application of the protocol and the charter does not confer jurisdiction on the court to quash the death sentence and release the applicant from prison. Secondly, find that the respondent state did not violate Articles 1, 4, 5, and 7 of the charter, and that the applicant was accorded a fair trial by the respondent state during the trial at the domestic courts. Thirdly, find that the death penalty is consistent with Articles 4 of the African Charter. Fourthly, dismiss the application for reparation. And lastly, make any other order this honorable court may deem right and just under the prevailing circumstances. Having considered the issue of jurisdiction, admissibility, merits, the court has arrived at a decision, which I will now read the operative parts of the judgment. For these reasons, the court unanimously on jurisdiction dismisses the objection to its jurisdiction raised by the respondent state. The court declares that it has jurisdiction. On admissibility, dismisses the objection to the admissibility of the application, declares that the application is admissible. On merits, the court finds that the respondent state has not violated the applicant's right to fair trial under Article 1 sub B of the Charter with regard to being presumed innocent until proven guilty by a competent court. The court also on merit finds that the respondent state has not violated the applicant's right to effective counsel under Article 7(1)(c) of the Charter. The court also on merit finds that the respondent state has not violated the applicant's right to a fair trial entrenched in Article 7(1) of the Charter with regard to the allegation of conviction on the basis of insufficient, unreliable, and circumstantial evidence. The court also finds that the respondent state has violated the applicant's right to life under Article 4 of the Charter in relation to the mandatory nature of the death penalty. The court also finds that the respondent state has violated the right to dignity under Article 5 of the Charter by prescribing hanging as a method of the execution of the death penalty. The court also finds that the respondent state has violated the right to be tried within a reasonable time, protected under Article 7 sub 1 sub D of the Charter. Lastly, on merits, the court finds that the respondent state has violated Article 1 of the Charter. On reparations, pecuniary reparations, the court dismisses the applicant's prayer for damages for material prejudice. The court dismisses the applicant's prayer related to the reimbursement of legal fees. The court grants the applicant's prayer for reparation for the moral prejudice and awards her the sum of Tanzania shillings 7 million. The court orders the respondent state to pay the amount set out under above as read, tax-free as fair compensation within 6 months from the date of notification of judgment, failure of which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Bank of Tanzania throughout the period of delayed payment until the accrued amount is fully paid. On non-pecuniary reparation, the court dismisses the applicant's prayer for release from prison. The court orders the respondent state to take all necessary measures upon notification of this judgment within 6 months to remove the mandatory death penalty from its laws. The court orders the respondent state to take necessary measures through its internal processes and within 1 year of the notification of this judgment for the rehearing of the case on the sentencing of the applicant through a procedure that does not allow the mandatory imposition of the death sentence. The court also on non-pecuniary reparation orders the respondent state to publish this judgment within a period of 3 months from the date of notification on the websites of the judiciary and the Ministry of Constitutional and Legal Affairs, and ensure that the text of the judgment is accessible for at least 1 year after the date of publication. Lastly, on non-pecuniary reparation, the court orders the respondent state to submit to it within 6 months from the date of notification of this judgment, a report on the status of implementation of the orders set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On cost, the court orders that each party shall bear its own cost. This judgment is signed by the bench as earlier read, including the Robert Eno, the registrar. In accordance with Article 28(7) of the protocol and Rule 71 of the rules, the separate opinion of Justice Blaise Shikaya is appended to this judgment. Done at Arusha this first day of December in the year 2022 in English and French, the English test being authoritative. I thank you.
Telle est la décision de la Cour. Nous allons
The
passer
court. We shall now move
à l'affaire suivante.
to the next matter,
Ticket Mwembe Pile,
the matter of TK Mwambipile and Equality Now versus the United Republic of Tanzania. And this judgment will be read by our colleague, Honorable Justice Chizumila. Judge Chizumila, you have the floor.
This is the matter of TK Mwambipile and Equality Now versus the United Republic of Tanzania, application number 042 of 2020, and it's a ruling. The court, composed of Blaise Chikaya, the Vice President, Ben Kioko, Rafa Ben Ashur, Susan Menge, Tugilane R. Chizumila, Chafika Ben Saula, Stella I. Anukam, Dumisa Bin Sebeza, Modibo Sako, Dennis D. Ajay, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, herein after referred to as the Protocol, and Rule 9.2 of the Rules of Court, herein after referred to as the Rules, Justice Imani D. Aboud, President of the Court and a national of Tanzania, did not hear the application. Facts of the matter. The application concerns an alleged ban by the respondent state of pregnant girls from attending public primary and secondary schools and preventing them from reaccessing the schools even after delivery. The applicants, TK Mwambipile and Equality Now, allege that the ban violates the rights to education and non-discrimination. The applicants pray to the court to, one, declare that the expulsion and exclusion of pregnant girls and adolescent mothers from accessing public education in the respondent states violates their right to education. Two, declare that the current policy implemented by the respondent state that prohibits pregnant girls and adolescent girls from attending schools, both in written policy and in state declarations, is grossly unlawful, discriminatory, not in the best interest of the child, and that it violates their right to non-discrimination. Three, order the respondent state to immediately revoke the prohibitive policy, both the expulsion regulation and implementation of declarations, and amend its legislation to protect the right to education. Four, order the respondent state to immediately repeal regulation number 4 of the education regulations, expulsion and exclusion of pupils from schools of 2002 to remove the word wedlock as a ground for expulsion and amend the Marriage Act of 1971 to harmonize the age of marriage to 18 for both boys and girls. 5, order the respondent state to develop strategies, programs, and nationwide campaigns that focus on addressing the issue of teenage pregnancies through public education, all awareness on sexual and reproductive health and rights, as well as on ending child marriages, as this increased community knowledge on family planning and contraceptives will support efforts to address the high rate of teenage pregnancies. 6, order the respondent state to develop strategies and nationwide campaigns to enable teenage mothers to attend school. This may range from providing subsidies to enable girls and girls with children to attend school, to developing alternative schooling offering the same quality and standard of education as offered in mainstream schools, as well as developing and implementing relevant re-entry policies for girls who have given birth. 7, order the respondent state to put in place constitutional, legislative, and administrative measures to guarantee the right to education, including its enforceability domestically, as well as a right to remedies, including reparations, and eradicate discriminatory laws and policies that impede the right to education within 6 months. Order the respondent state to report to the court within a period of 6 months from the date of judgment on the implementation of this judgment and consequential orders. Number 9, order the respondent state to publish the judgment in this matter on the official website of its judiciary and of the ministry responsible for legal affairs within 2 months from date of notification of this decision. Declare violations of other human rights which were not specifically mentioned by the applicants in this application. Number 11, issue any other remedy and or relief that the court will deem necessary to grant. And finally, order the respondent state to pay the applicant's costs. In its response, with regard to the court's jurisdiction and admissibility of the application, the respondent state praised the court to order as follows. 1, that the African Court on Human and People's Rights is not vested with jurisdiction to adjudicate the application. 2, the application has not made the admissibility requirements provided by Article 56 of the Charter and Rule 50 of the rules. 3, the application be declared inadmissible. 4, that the application be dismissed. The respondent state praised the court to grant the following orders with respect to the merits of the application. 1, that the respondent state has not violated Article 17(1) of the Charter, Article 11 of the African Children's Charter, and Article 12 of the Maputo Protocol. 2, that the application be dismissed for want of merit. And 3, that the cost of the application be borne by the applicants. Having gone through jurisdiction, admissibility, and request for provisional measures, the court under its operate has jurisdiction. On admissibility, by a majority of 8 for and 2 against, Justice Blaise Chikaya and Justice Rafa Ben Ashur dissenting declares that the application is inadmissible. On costs, orders that each party shall bear its own costs. This is signed by the bench that I mentioned above, plus the registrar, Dr. Eno, and in accordance with Article 28(7) of the protocol and the Rule 71 of the rules, the joint dissenting opinion of Justice Blaise Chikaya and Justice Rafa Ben Ashur, and the separate opinion of Justice Chafika Ben Saula are appended to this ruling. Done at Arusha, this first day of December, in the year 2022 in English and French, the English text being authoritative. That is the judgment of the court. Thank you, Mr.
Merci, juge Tuzmila. Telle est la décision.
That is the decision of the court. The court is wondering whether the parties, the respondent state, and the applicants are represented.
We are speaking about
Yes, Honorable President, the counsel for applicant is represented.
Ok, merci.
Otike Makimbile.
Merci. La Cour prend acte de cela.
The court notes.
Oui. Pourriez-vous prendre la parole, s'il vous plaît?
Would you mind taking the floor?
We want to take the floor. Amen.
Honorable judges of the African Court of Human People's Rights, I was representing the applicant in the previous application, which the judgment has already been read by honorable judges, and we really appreciate for the work by the court. Thank you so much.
Merci.
The court will rise for a few minutes to be reconstituted for the other matters. Thank you.
Get seated, please. The court resumes and will deliver judgment in the matter of Mamadou Dabo and 55 others against Republic of Mali. And the judgment will be delivered by Justice Bensaoula.
Merci, Madame la Présidente. Donc, en l'affaire,
Honorable President, in the matter of Mamadou Dabo and others versus the Republic of Mali, application number 027 of 2017, ruling delivered as follows. The court composed of Imani Di Dub, President, Blaise Chikaya, Vice President, Ben Kyoko Rafa Benashur, Susan Menge, Tujilane Chizumila, Chafika Paula, Stella Anukam, Dumisa Sebesa, Denis Ajay, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, herein referred to as the Protocol, and Rule 921 of the Rules Court, herein referred to as the rules, Justice Modibo Sako, Judge of the Court and National of Mali, did not hear the application. Subject of the application, a fact of the matter, it emerges from the record that on 11 June 2012, the Workers' Trade Union Committee of LTA Mali SA gave notice of a strike to the employer. In the notice, they called for the immediate cessation of the arrest and dismissal proceedings in respect of 56 workers, 26 of whom are trade unionists, the payment of arrears in respect of 7% 7 salary, increase for 32 months, and performance bonus from 2011. On 19 June 2012, negotiations failed and the strike was called from 28 to 29 June 2012. Following the strike, the director of LTA Mali SA by correspondence number AMS 097-2012 HR dated 13 July 2012 sought clearance from the Regional Directorate of CAIS, First Administrative Region of Mali, to dismiss 26 workers, including the applicant, Mr. Mamadou Dabo, and all members of the Trade Union Committee. In response, the Regional Labor Officer of CAIS by letter number 0263 DRTK dated 13 July 2012 authorized the dismissal of 26 workers and approved the suspension of 30 other workers from work. The FINAME, in response to these measures, issued a 3-day strike notice from 18 to 20 July 2012 on behalf of the trade union committees of LTA Mali SA and Sadiola Gold Mines Operating Company SA. The respondent States Minister of Labor, Employment and Vocational Training was duly informed of the matter through the relevant channels. To avoid the risk of the strike spreading to other regions of Mali, the Ministry of Labor, Employment and Vocational Training, by decision number 2012-0192 MTEFP-SG of 28 September 2012, formed an arbitration council to resolve the dispute between LTA Mali SA and SEMOSA and their employees affiliated to the FINAME in accordance with Articles L20 225 and SQ of the Labor Law of Mali. On 7 January 2013, the Arbitration Council released resolution number 001 CA containing the finding of its arbitration, which read as follows. Mali A Council ordered the suspension of the arrest warrant issued by the Malian judiciary in respect of the 14 trade union leaders by a letter received at the Secretariat of the Arbitration Council on 1 February 2013. LTA Mali SA objected to the implementation of the Arbitration Council decision number 001 CA of 7 January 2013. Subsequently, a group of workers comprising Ismaila Traore and 12 other workers filed a lawsuit against LTA Mali SA before the Kayes Labor Court seeking an enforcement order in respect of the Arbitration Council's decision. The said court, in its ruling number 015 of 24 June 2013, dismissed the request for entitlement and damages for lack of jurisdiction. By later number 0039 MTA CAB dated 28 January 2014, the Minister of Labour and Social Affairs and Humanitarian Affairs of the respondent state directed LTA Mali SA to duly enforce decision number 001 of the Arbitration Council, but to no avail. On 25 March 2014, FNAME filed a lawsuit against LTA Mali SA seeking the enforcement of the Arbitration Council's award decision, and on the 2nd of June 2014, the court rendered a ruling declining jurisdiction due to the collective nature of the dispute on the one hand, and due to the fact that the objection to implementation filed on February 1, 2013 by LTA Mali SA rendered the award null and void on the other hand. On the 30th of June 2014, the beneficiary workers from the arbitration award through their trade union, the CSTM, by letter number 14-00108, requested the Minister of Labour, Public Employment and Institutional Relations of Mali to request the Cabinet to implement the Arbitration Council's decision of the 7th January 2013. On the 20th of October 2015, the Minister of Labour, who was in charge of the matter, submitted a written memorandum at a cabinet meeting seeking to enforce the decision of the Arbitration Council. Cabinet decided to withdraw the approval of the said memorandum on the grounds that the mining sector is not a core sector in the sense of ILO standards. On the 7th of January 2016, the Minister of Labour notified the said cabinet decision to the Secretary General of the Central Trade Union of the Confederation of Trade Unions of Malian Workers by letter number 00010 MTFP-SG, who in turn notified the said decision to the members, including the applicants Mamadou Dabo and others. On the 1st of November 2016, another group consisting of Mamadou Dabo and 25 other workers filed a case before the civil court of the municipality of Bamako Commune, second district, claiming the amounts awarded by the Arbitration Council. The court, in its decision number 145 of 5 April 2017, dismissed the case for lack of jurisdiction. On the 10th of January 2018, the same group of workers filed another case before the Labour Court of Bamako seeking enforcement of the Arbitration Council award. By order number 09 of 22 January 2018, the president of the said court issued an order dismissing the said case. So on 9 February 2018, the workers appealed the order before the Bamako Court of Appeal, in which a decision was yet to be issued at the time of filing the application. And to say that the respondent said violated Article 7.1 of the Charter and Article 8 of the Universal Declaration of Human Rights, finds that the respondent state violated Article 1 of the ILO Convention C-87 and Articles 20 and 21 of the Constitution of Mali of 25 February 1992. The applicants also pray the court to order the respondent state to pay their salary arrears from July 2012 to 31st August 2018. Order the respondent state to pay an amount of 80 million CFA francs as arrears in respect of a 1999-7 salary increment that is a total of 32 months. Order the respondent state to pay an amount of 4 billion CFA francs as unpaid performance bonus. Order the respondent state to pay an amount of 6 million CFA francs per worker as reparations for damage suffered and lost earning. Order the respondent state to expedite the payment of half of their entitlement. Order the respondent state to issue a work certificate to each former worker. Order the respondent state to pay a fine 4 million CFA francs per worker each day of delayed payment of the date pronouncement of the decision. Order the respondent state to bear the cost. The respondent state praised the court to declare the application inadmissible. In the alternative, the respondent state praised the court to dismiss the application for being unfounded. Order the applicants to bear the costs. Operative part: for these reasons, the court unanimously concluded that the decision that it has jurisdiction on admissibility upholds the respondent state objection based on non-exhaustion of local remedy. Declare the application inadmissible. On costs, orders the order that each party shall bear its own costs, and that they then declare the fact that there was no exhaustion of local remedies, declares the application inadmissible, and on cost orders that each party shall bear its own cost, signed by the judges named herein. Done in Arusha on the 1st of December 2022 in Arabic, English, and French, and the French text, therefore, is the one that is the basis of this. Thank you.
This is the decision of the court. In the matter of Adama Diarra against the Republic of Mali, judgment will be delivered by Honorable Justice Menge.
Merci, Madame la Présidente.
The matter of Adama Diarra, aka Vieux Blen, versus the Republic of Mali, application number 047-2020, ruling of 1st December 2022. The court, composed as mentioned in the previous matter, in accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9.2 of the Rules of Procedure of the Court, hereinafter referred to as the Rules. Judge Modibo Sako, a Malian national, did not hear the application. Subject of the application are as follows. It emerges from the records that on 22 October 2020, the Deputy Prosecutor in instance of Bamako Commune 3 District of High Court placed the applicant under detention following a joint complaint lodged by the two magistrates' unions of the respondent state, namely the Syndicat Autonome de la Magistrature and the Syndicat Libre de la Magistrature, for contempt of court and insults committed through an information system by posting a video on the internet. According to the said complaint, the applicant gratuitously attacks the magistrates in charge of the case of the state versus Sidiki Diabate, who, according to him, refused in flagrant violation of the laws of the Republic to hear the latter, the accused, who is in detention. The applicant submits that under Article 83 of the Respondent State's Code of Criminal Procedure, trial should take place within 3 months. The applicant further avers that under Article 151 of the said code, he was entitled to apply for bail at any stage of the proceedings, provided that this measure does not constitute a threat, that he is guaranteed legal representation. He further avers that by applications dated 25 October and on 10 and 11 November 2020, his 3 lawyers requested that he be granted bail. The applicant states that the said 3 applications for bail were listed on the hearing of the 15th December 2020. By preliminary ruling of number 25 of 27 January 2021, the Bamako Commune 3 High Court granted the applicant the bail. The prosecution appealed the said ruling on the 10th of June. According to one of the applicant's lawyers, the said preliminary ruling number 25 of 2021 was upheld by the appeal court on the 25th of February 2021, and the applicant was released on bail. The prayers of the parties. In his application, the applicant prays the court to order the respondent state the following: review its legislation to ensure strict separation of prosecutorial power and judicial power by prohibiting the public prosecutor from issuing detention orders as a guarantee of non-repetition of the said violations. Ensure the independence of the authorities responsible for adjudicating cases brought by magistrates by bringing the procedure into line with that which pertains in complaints against judges, in particular by vesting jurisdiction in the Supreme Court, and publish the various judgments in 2 media outlets. As reparation for the moral damage suffered, the applicant prays the court to order the respondent state to pay 50 million CFA as reparation for the moral justice suffered by the applicant and his family. In follow-up, the applicant prays the court to request the respondent state to report back to it on the measures taken to cease the said violations by ordering the release of the applicant within 1 month. As regards costs, the applicant prays the court to order the respondent state to bear all costs. For its part, the respondent state prays the court to declare the application inadmissible as to form. In the alternative, on the merits, dismiss it as founded. The operative part, the court, for these reasons, unanimously on jurisdiction declares that it has jurisdiction. On admissibility, uphold the objection to admissibility based on non-exhaustion of local remedies, declares the application inadmissible. On costs, orders that each party shall bear its own costs, and the judgment has been signed by the judges as mentioned earlier in the previous matter, and Robert Eno as the registrar. Done in Arusha on the first day of December in the year 2022 in English and French languages, the French text being authentic. I thank you.
This is the decision of the court. In the matter of Fungi Eric against Benin,
va lire celle-là. Ok. On se lance en français, ou je marche en français.
Ça
bon?
coupe, ça coupe, ça coupe.
Registrar, is there any lawyer representing the parties? Lawyers? Is there any lawyers representing the parties? In the matter of Fungi Eric against Benin, the judgment will be read or delivered by Honorable Vice President.
Merci, Madame la Présidente. L'affaire
President, the matter of Fungi Eric Nude Huenu versus the Republic of Benin. The court, composed of Imani Di Aboud, President, Blaise Chikaya, Vice President, Ben Kyoko, Rafa Benashur, Suzanne Menge, Tudijane Chizumila, Shafika Ben Saula, Stella Anukam, Dumisa Ntebesa, Modibo Sako, Denis Ajayi, and the Registrar Robert Eno. Subject of the application, fact of the matter, it emerges from the application that on the 2nd of July 2018, the respondent state passed law number 2018-02, amending and supplementing organic law number 94027 of 18 March 1999, relating to the High Court. He avers that the said law contains provisions that violate the principle of independence of the judiciary. He claims that the executive wields undue influence over the HJC and that judges have no remedy against the sanctions pronounced against them by the HJC. He also challenges law number 2018-16 of 4 January 2018 pertaining to the status of the judiciary, which bars judges from going on strike. He notes that although the said law was declared unconstitutional by the Constitutional Court by its decision number DCC 18003 of 22 January 2018, the same court by decision DCC 18141 of 28 January 2018 reversed the earlier decision by declaring the same law consistent with the Constitution. The applicant also challenges law number 2019-40 of 7 November 2019, amending the respondent state constitution of 11 December 1990, hereinafter referred to as the constitutional amendment, and law number 2019-43 of 15 November 2019 pertaining to the Electoral Code, herein referred to as the Electoral Code, which were ruled constitutional by the Constitutional Court in decisions number DCC 19504 of 6 November 2019 and DCC 19525 of 14 November 2019, respectively. Finally, he challenges memorandum number 914 MEFDC SGM DGI of 13 November 2017, issued by the Director General of Taxes. Prayers of the parties, application and the supplementary submission. The applicant prays the court so the court declares that it has jurisdiction, declare the application admissible, declares that he has the right to have effect given to the right protected by the instruments to which the respondent state is a party within the meaning of Article 1 of ECOWAS Protocol on Democracy and Article 1 of the Charter, finds that the violation of the applicant's human rights are well-founded and that the respondent state indeed violated the human rights protected by Article 1, 2, 3, 7, 9, 10, 11, 26, and 56 of the Charter, Article 2, and 1926 of the ICCPR, Article 8, 10, 1930 of the UDHR, Article 10 of the ACDG, and 33 of the ECOWAS Democracy Protocol. So all necessary measures for the respondent state to execute diligently the decision of the court rendered in application number 13 01529 and so on, order the respondent take violated Article 26 of the Charter by removing from the HJC officers of the executive branch, and this was carried by an absolute majority through free and fair, transparent election, with Judge Adei being dissident. On item 8, order such measures ensuring non-repetition as the court may deem necessary, unanimously states that the respondent state did violate Article 26 of the Penal Code. On reparations, at the majority of 10 judges and 1 against, that of Judge Chafika and Ben Saula being the ones who voted against, dismisses the request for the payment of 1 billion CFA francs as a monthly lump sum, interest of non-enforcement of the judgment delivered in the Eastern case, and 500 million francs as monthly lump sum interest for the enforcement of the ruling of provisional measures of the 5th of May and 25 September 2020, and the judgment on 4 December 2020 rendered in application number 003-2020, Honge Eric Nduedun and the Republic of Benin unanimously dismisses request for restitution of the sum of 15 million CFA francs in respect of legal and procedural costs, and 5,000 CFA francs in respect of mailing and communication costs. On 12, orders the respondent state to pay the applicant within a period of 3 months the sum of 5 million CFA francs as reparations for moral damage within 6 months of notification of this judgment, failing which it will have to pay default interest calculated on the basis of the applicable rate of the Banque Centrale des États de l'Afrique de l'Ouest, BCAO, for the entire period of delay until full payment of the amount due. Dismiss the request for the reconstitution of Parliament. Sorry, let me recap. On 13, dismisses the request for the reconstitution of Parliament. It dismisses the request for annulment of the decisions of the Constitutional Court. Orders the respondent state to take within 6 months of the notification of this judgment all measures to make the structure of the HJC statutory and functionally consistent with Article 28 of the Charter. On the one hand, by repealing the following provision of the HJC organic law: those that make the President of the Republic a member of the HJC and President of the HJC, those that entitle the President of the Republic to appoint members of the HJC, and those that make other members of the executive of the HJC, and on the other hand, by making the President of the Supreme Court head of the HJC. Orders the respondent state to take within 6 months all measures to make Article 410(3) of the Criminal Code consistent with Article 9(2) of the Charter and Article 19 of the ICCPR by guaranteeing freedom of opinion and expression in relation to criticism of judicial decisions. Orders the respondent state to take all measures to comply with Article 30 of the Protocol by implementing the decisions rendered in application number 003 of 2020, Fungi Eric Nudeunu versus Benin. Orders the respondent state to publish the operative part of this judgment within 1 month of the date of its notification on the websites of the government, the Ministry of Foreign Affairs, the Ministry of Justice, and the official gazette of the respondent state for a period of 12 months. On implementation reporting, orders the respondent state to submit to the court within 6 months a report on the implementation of paragraphs 12, 15, 16, 17, and 18 of this operative part. These timelines shall run from the date of notification of this judgment. On the request for provisional measures, finds that the request for provisional measures are moot. On costs, orders that each party shall bear its own costs. Signed by the judges which were mentioned earlier, and in accordance with Article 28(7) of the Protocol and Rule 71 of the rules, the dissenting opinions of Justice Chafika Ben Saula and Justin Dennis Ajay are appended to this judgment. Done at Arusha, this first day of December in the year 2022 in English and French languages, the French text being authoritative. Thank you.
This is the decision of the court. In the matter of Kobina against Republic of Cote d'Ivoire, the judgment will be delivered by Honorable Vice President.
It's simple. It's simple.
There are some changes, Honorable Sako.
Requête en révision numéro 001-2022
Review number 001 of 2022 in the matter of Kobina versus the Republic of Cote d'Ivoire, ruling of 1 December 2022. The court, composed of Imani D. Aboud, President, Blaise Shiga, Vice President, Ben Kioko, Rafa Benashur, Susan Menge, Chijulani R. Chizumila, Chafika Ben Saula, Stella I. Anukam, Dumisa B. Ntsebeza, Modibo Sako, Dennis D. Ajay, judges, and Robert Eno, registrar. Subject of the application. On 2 December 2021, the court delivered a judgment hereinafter the judgment in application number 034-2017, Kwadwo Kobina versus Republic of Cote d'Ivoire. Following the judgment, the applicant filed an application for review on 17 January 22, claiming the emergence of new and erroneous facts of which he became cognizant and which, in his view, constitute new evidence. Prayers of the parties. The applicant praised the court to review its judgment, in particular, to find that by declaring that it had no jurisdiction to deal with the alleged violations committed between the date of entry into force of the protocol in respect of the respondent state, the court introduced a new fact into the case and disregarded the following continuing nature of the violation of his right to be tried by an impartial court. Consider that he had no remedy against the decision of the Civil Service Disciplinary Board when it refused to reinstate him in his post. 3. Recalculate the time limits for local remedies in respect of his immovable property, starting from the date on which the domestic courts were seized until the date on which his application was examined by this court in December 2021, and find that in the present case, local remedies were prolonged unduly. Re-evaluate the amount awarded as reparation for moral damage suffered by the members of his family and by himself, and set the quantum of reparation higher than or at least equal to the amounts awarded to the wife, children, and Sébastien Germain Ajavon in application 013 of 2017, Sébastien Germain Ajavon versus the Republic of Benin. For it, the respondent state praised the court to declare that it lacks personal jurisdiction insofar as the application for review was lodged after the 30th of April 2021, the date on which the withdrawal of the declaration allowing individuals to lodge applications directly against it took effect. Declare the application for review inadmissible for lack of evidence of new facts. Dismiss the request for reassessment of the amount of reparation for non-material damage awarded to the original judgment. Order the applicant to bear the costs of the proceedings. For this reason, the court unanimously on jurisdiction dismisses the objection to the court's personal jurisdiction, declares that it has jurisdiction. On admissibility, finds that the application has identified the judgment of which a review is sought and was filed within the required time limits. Finds that the challenges of the judgment of 2 December 2021 do not constitute new facts, and that therefore no new evidence has been adduced. Decide inadmissible the application for review of the court's judgment of 2 December 2021, delivered in application 034-2027, Kwadwo Kobina versus Cote d'Ivoire. Costs. Decides that each party shall bear its own costs. Signed by the judges Aboud, Chikaya, Kioko, Benashur, Menge, Chizumila, Ben Saula, Anukam, Ntsebeza, Sako, Ajay, judges, and Robert Eno, registrar. done at Arusha this first day of December in the year 2022 in English and in French, the French text being authentic.
This is the decision of the court. We have come to the end of this delivery of judgment event. And on behalf of the court, I would like to thank and appreciate all those attended this event of delivery of judgment of this last session of the African Court. I would also like to recognize the presence of the representative of the OHCHR and his delegation, and also recognize the presence of representatives from the mechanism, and all I recognize the presence of all whom you are in this room, especially the students who took time and interest to come and hear the delivery of judgments of this court. Since this is our last session and we are closing sessions of this year, 2022, I would also like to wish all of you a pleasant, happy, Merry Christmas and a Happy New Year with health and prosperous 2023. Lastly, I would like to invite all of you to have light refreshment, which will be offered outside the court with the complement of this court. Thank you very much.
As the president said, you're all warmly welcome for the light refreshments